Justice Bradley, it may be that it is obnoxious. It is the obnoxious thing in its mildest form, but illegitimate and unconstitutional practices get their first footing in that way, namely by silent approaches and slight deviations from legal modes of procedure. This can only be obviated by adhering to the rules that constitutional provisions for security of persons and property should be liberally construed. A close and literal construction deprives them of half their efficacy and leads to the gradual depreciation of the rights, as if it consisted more in sound than in substance. It is the duty of the courts to be watchful for the constitutional rights of the citizens and against any stealthy encroachment thereon. Their motto should be obsta principiis. It will be an evil day for American liberty if the theory of a government outside supreme law finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violations of the principles of the Constitution. Constitutional rights would be of little value if they could be indirectly denied. Supreme Court Justice Field, there is no such thing as a power of inherent sovereignty in the government of the United States. In this country, sovereignty resides in the people, and Congress can exercise power which they have not, and Congress can exercise power which they have not by their Constitution entrusted to it. All else is withheld. All rights and safeguards contained in the first 8 amendments to the federal Constitution are equally applicable. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. An unconstitutional act is not law. It confers no right, imposes no duty, affords no protection, it creates no office, it is in legal contemplation as inoperative as though it had never been passed. In our country, the people are sovereign and the government cannot serve its relationship to them by taking away their citizenship. There can be no sanctions or penalties imposed upon one because of his exercise of a constitutional right. The claim and exercise of a constitutional right cannot be converted into a crime. A denial of them would be a denial of due process of law. 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that state officials acted in violation of federal law. United States Senator convicted of, among other things, bribery. No man or woman in this country is so high that he is above the law. No officer of the law may set that law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. Acts in excess of judicial authority constitute misconduct, particularly where judges deliberately disregard the requirements of fairness and due process. Society commitment to institutional justice requires that judges be solicitous of the rights of persons who come before the court. Acts in excess of judicial authority constitutes misconduct, particularly where a judge deliberately disregards the requirements of fairness and due process. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. The innocent individual who is harmed by an abuse of government authority is assured that he will be compensated for his injury. I do not understand the government to contend that it is any less bound by the obligations than a private individual would be. It is not the function of our government to keep the citizens from falling into error. It is the function of the citizens to keep the government from falling into error. Before sending a person to jail for contempt or imposing a fine, judges are required to provide due process of law, including strict adherence to the procedural requirements contained in the Code of Civil Procedure. Ignorance of these procedures is not a mitigating but an aggravating factor. No man in this country is so high that he is above the law. No officer of the law may set the law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its functions is only the more strongly bound to submit to the supremacy and to observe the limitations which it imposes on the exercise of the authority which it gives. 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that the state officials acted in violation of federal law. Dismissal of suits. Note, copied verbiage. We are not lawyers. It can be argued that to dismiss a civil rights action or other lawsuit in which a serious factual pattern or allegation of a cause of action has been made would itself be violating of procedural due process, as it would deprive a pro se litigant of equal protection of the law. Vice versa, a party who is represented by counsel. Also see Federal Rules Civil Procedure Rule 60, relief from judgment or order. A, clerical mistakes, and B, mistakes, inadvertence, excusable neglect, newly discovered evidence, fraud, etc. 11th Amendment does not protect state officials from claims for prospective relief when it is alleged that the state official acted in violation of federal law. In a motion to dismiss, the material allegations of the complaint are taken as admitted. From this vantage point, courts are reluctant to dismiss complaints unless it appears the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. However, in Cochran's choice of words, he has set out allegations supported by affidavit and nowhere denied that Kansas refused him privileges of appeal which it afforded to others. The state properly conceded that if the alleged facts pertaining to the suppression of Cochran's appeal are disclosed as being true, there would be no question but that there was a violation of the Equal Protection Clause of the 14th Amendment. Due process of law and the equal protection of the law are secured if the laws operate on all alike and do not subject the individual to an arbitrary exercise of power of the government. Undoubtedly, and the 14th Amendment forbids any arbitrary deprivation of life, liberty, or property and secures equal protection to all under like circumstances in the enjoyment of their rights. It is enough that there is no discrimination in favor of one as against another of the same class, and due process of law within the meaning of the Fifth and 14th Amendments is secured if the laws operate on all alike and do not subject the individual to an arbitrary exercise of power of government. The rule of equity requires the same means and method to be applied impartially to all the constituents of each class, so that the law shall operate equally and uniformly upon all persons in similar circumstances. Our whole system of law is predicated on the general fundamental principles of equality of application of the law. All men are created equal before the law. This is a government of laws and not of men. No man is above the law. Are all maxims showing the spirit in which legislators, executives, and courts are expected to make, execute, and apply laws. But the framers and adopters of the 14th Amendment were not content to depend upon the spirit of equity, which might not be insisted on by local public opinion. They therefore embodied the spirit of a specific guarantee. A state trial court's refusal to instruct the jury on an entrapment defense in a second trial on drug sale charges amounted to prejudicial constitutional error where evidence presented at a first trial warranted such an instruct. To read entire text of the opinion, see, I'm not going to go through all that. Judicial immunity. Judicial immunity, page For more citations and new articles regarding the topic, see also 42 U.S.C. 1983, Availability of Equitable Relief Against Judges. Note, copied verbiage, we are not lawyers. Judges have given themselves judicial immunity for their judicial function. Judges have no judicial immunity for criminal acts, aiding, assisting, or conniving with others who perform a criminal act, or for their administrative ministerial duties, or for violating a citizen's constitutional rights. When a judge has a duty to act, he does not have discretion. He is then not performing a judicial act. He is performing a ministerial act. Nowhere was the judiciary given immunity, particularly nowhere in Article 3. Under our Constitution, if judges were to have immunity, it could only possibly be granted by amendment, and even less possibly by legislative act. As Article 1, Section 9 and 10, respectively, in fact, expressly prohibit such, stating, no titles of nobility shall be granted by the United States, and no states shall grant any titles of nobility. Most of us are certain that the Congress itself does not understand the inherent lack of immunity for judges. Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court, not the United States Supreme Court, one motherfucking Supreme Court, all right? And in such inferior courts shall hold their offices during good behavior. Tort and Insurance Law Journal, Springs, 1986, 21 in 3, page 509 through 516, Federal Tort Law, judges cannot invoke judicial immunity for acts that violate litigants' civil rights. Robert Craig Waters. No judicial process, whatever form it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence. Justice Douglas, in his dissenting opinion on page 140, said, if federal judges break the law, they can be prosecuted. Justice Black, in his dissenting opinion on page 141, said, judges, like other people, can be tried, convicted, and punished for crimes. The judicial power shall extend to all cases in law and equity arising under this Constitution. Note, any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge is engaged in acts of treason. The U.S. Supreme Court has stated that no state legislator, executive, or judicial officer can war against the Constitution without violating his undertaking to support it. There is a general rule that a ministerial officer who acts wrongfully, although in good faith, is nevertheless liable in a civil action and cannot claim the immunity of the sovereign. A judge must be acting within his jurisdiction as to subject matter and person to be entitled to such immunity from civil action for his acts. Constitutionally, and in fact of law and judicial ruling, state, federal, magistrate judges, or any government actors, state or federal, may now be held liable if they violate any citizen's constitutional rights, privileges, or immunities or guarantees, including statutory civil rights. A judge is not immune from tortious acts committed in a purely administrative, non-judicial capacity. Generally, judges are immune from suit for judicial acts within or in excess of their jurisdiction, even if those acts have been done maliciously or corruptly. The only exception being for acts done in the clear absence of all jurisdiction. The courts are not bound by an officer's interpretation of the law under which he presumes to act. The particular phraseology of the Constitution of the United States confirms this and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. In declaring that what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally, but those only which shall be made in pursuance of the Constitution have that rank. All law, rules, and practices which are repugnant to the Constitution are void, since the 14th Amendment to the Constitution states, no state's jurisdiction shall make or enforce any law which shall abridge the rights, privileges, or immunities of citizens of the United States, nor deprive any citizen of life, liberty, or property without due process of law or equal protection under the laws. This renders judicial immunity unconstitutional. Where there is no jurisdiction, there can be no discretion, for discretion is incident to jurisdiction. In 1996, Congress passed a law to overcome this ruling, which stated that the judicial immunity doesn't exist. Citizens can sue judges for prospective injunctive relief. Our own experience is fully consistent with the common law's rejection of a rule of judicial immunity. We never have had a rule of absolute judicial immunity. At least 7 circuits have indicated affirmatively that there is no immunity to prevent irreparable injury to a citizen's constitutional rights. Subsequent interpretations of the Civil Rights Act by this court acknowledges Congress's intent to reach unconstitutional actions by all state and federal actors, including judges. The 14th Amendment prohibits the state, federal, from denying any person, citizen within its jurisdiction the equal protection under the laws. Since a state or federal acts only by its legislative, executive, or judicial authorities, the constitutional provisions must be addressed to those authorities, including state and federal judges. We conclude that judicial immunity is not a bar to relief against a judicial officer acting in his or her judicial capacity. A judge is not immune from tortious acts committed in purely administrative, non-judicial capacity. However, even in a case involving a particular attorney not assigned to him, he may reach out into the hallway, having his deputy use excessive force to haul the attorney into the courtroom for chastisement or even incarceration. A superior court judge is broadly vested with general jurisdiction, provided the judge is not divested of all jurisdiction. He may have his actions excused as per this poor finding. Note, by law, a judge is a state officer. The judge then acts not as a judge, but as a private individual in his person. When a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are not voidable, but void, and of no legal force or effect. The U.S. Supreme Court stated that when a state officer acts under a state law in a manner violative of the federal Constitution, he comes into conflict with the superior authority of that Constitution, and he is in that case stripped of his official or representative character and is subject in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Some defendants urge that any act of a judicial nature entitles the judge to absolute judicial immunity, but in a judicial vacuum, that is, absence of all jurisdiction, the second prong necessary to absolute judicial immunity is missing. A judge is not immune from tortious acts committed in a purely administrative non-judicial capacity. The Ninth Circuit Court of Appeals reversed an Arizona District Court dismissal based upon absolute judicial immunity, finding that both necessary immunity prongs were absent. Later, in Ashelman versus Pope, 1986, the Ninth Circuit Court in Bannock, E-N-B-A-N-C, criticized the judicial nature analysis it analyzes it had published in Rankin as unnecessarily restrictive, but Rankin's ultimate result was not changed because Judge Howard had been independently divested of absolute judicial immunity by his complete lack of jurisdiction. When a judicial officer acts entirely without jurisdiction or without compliance with jurisdiction requisites, he may be held civilly liable for abuse of process even though his acts involved a decision made in good faith that he had jurisdiction. No man in this country is so high that he is above the law. No officer of the law may set the law at defiance with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law and are bound to obey it. It is the only supreme power in our system of government, and every man who, by accepting office, participates in its function, is only more strongly bound to submit to that supremacy and to observe the limitations which it imposes on the exercise of the authority which it gives. When a judge knows that he lacks jurisdiction or acts in the face of clear, valid statutes expressly depriving him of jurisdiction, judicial immunity is lost. It is a fact of law that the person asserting jurisdiction must, when challenged, prove that jurisdiction exists. Mere good faith assertion of power and authority jurisdiction have been abolished. The United States District Court is not a true United States court established under an Article 3 of the Constitution to administer the judicial powers of the United States therein conveyed. It is created by a virtue of the sovereign congressional faculty granted under Article 4.3 of the instrument of making all needful rules and regulations respecting the territory belonging to the United States. The resemblance of its jurisdiction to that of true United States courts in offering an opportunity to non-residents of resorting to a tribunal not subject to local influence does not change its character as a mere territorial court. Under federal law, which is applicable to all states, the U.S. Supreme Court stated that if a court is without authority, its judgment and orders are regarded as nullities. They are not viable, but simply void, they're not voidable, but simply void, and form no bar to a recovery sought even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. Federal law and Supreme Court cases apply to state court cases, okay? All federal law and Supreme Court cases apply in all state court cases, all right? So don't let them give you that horse shit that, oh, that Supreme Court case doesn't apply here. Bullshit. It does, all right? The federal government may neither issue directives requiring the state to address particular problems, nor command the state officers or those of their political subdivision to administer or enforce a federal regulatory program. It matters not whether policymaking is involved, and no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. Residual state sovereignty was also implicit, of course, in the Constitution's conferral upon Congress of not all governmental powers, but only discrete and enumerated ones. The term district courts of the United States, as used in the rules without an additional expressing a wider connotation, has its historical significance. It describes the constitutional courts created under Article 3 of the Constitution. Courts of the territories are legislative courts, properly speaking, and are not district courts of the United States. We have often held that vesting a territorial court with jurisdiction similar to that vested in the district courts of the United States does not make it a district court of the United States. Not only did the promulgating order use the term district courts of the United States in its historic and proper sense, but the omission of provisions for the application of the rules, the territorial courts and other courts mentioned in the authorizing act clearly show the limitations that was intended. We have held, however, that state legislators are not subject to federal direction. Justice Department. It is deeply distressing that the Department of Justice, whose mission is to protect the constitutional liberties of the people of the United States, should ever appear to be seeking to subvert them by extreme and dubious legal argument. Loss of First Amendment freedoms for even minimal periods of time unquestionably constitutes irreparable injury. There can be no sanctions or penalties imposed upon one because of his exercise of a constitutional right. No state shall convert a liberty into a license and charge a fee for therefore or thereof. If the state converts a right, liberty, into a privilege, the citizen can ignore the license and the fee and engage in the right, liberty with impunity. Rights to petition, freedom of association. Probable cause to assert provides details on how to determine if a crime has been or is being committed. Probable cause to search provides details on the belief that seizable property exists in a particular place or on a particular person. Probable cause is where known facts and circumstances of a reasonably trustworthy nature are sufficient to justify a man of reasonable caution in the belief that a crime has been or is being committed. Reasonable man definition, common textbook definition, comes from this case. Pro se writes, litigants can be assisted by unsolicited laymen during judicial proceedings. Following the simple guide of Rule 8F, that all pleadings shall be so construed as to do substantial justice. The federal rules reject that approach, that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome of, and accept the principle that the purpose of pleadings is to facilitate a proper decision on the merits. The court also cited Rule 8F, Federal Rules of Civil Procedure, which holds that all pleadings shall be construed to do substantial justice. The assertion of federal rights, when plainly and reasonably made, are not to be defeated under the name of local practice. The right to file a lawsuit pro se is one of the most important rights under the Constitution and laws. A next friend is a person who represents someone who is unable to tend to his or her own interest. Allegations such as those asserted by petitioner, however inartfully pleaded, are sufficient, which we hold to less stringent standards than formal pleadings drafted by lawyers. Pro se pleadings are to be considered without regard to technicality. Pro se litigants' pleading are not to be held to the same high standards of perfection as a lawyer. Pleadings are intended to serve as a means of arriving at a fair and just settlement of controversies between litigants. They should not raise barriers which prevent the achievement of that end. Proper pleading is important, but its importance consists in its effectiveness as a means to accomplish the end of just judgment. Members of groups who are competent non-lawyers can assist other members of the group achieve the goals of the group in court without being charged with unauthorized practice of law. The plaintiff's civil rights pleadings was 150 pages and described by a federal judge as inept. Nevertheless, it was held where a plaintiff pleads pro se in a suit for protection of civil rights, the court should endeavor to construe plaintiff's pleadings without regard to technicalities. It was held that a pro se complaint requires a less stringent reading than one drafted by a lawyer, per Justice Black in Conley versus Gibson. Due to sloth, inattention, or desire to seize tactical advantage, lawyers have long engaged in dilatory practices. The glacial pace of such litigation breeds frustration with the federal courts and ultimately disrespect for the law. There can be no sanctions or penalties imposed upon one because of his exercise of a constitutional right. The practice of law cannot be licensed by any state. The practice of law is an occupation of common right. Nowhere can be found a competent attorney that is able to execute the proper remedy without embarrassing the court. Corpus Juris Secundum 2, Volume 7, Section 25. Agresinger versus Hamlin. No accused may be deprived of his liberty as the result of any criminal prosecution, whether felony or misdemeanor, in which he was denied assistance of counsel. At the present time, bar attorneys, public vessels, are not assistants of counsel, and defense is severely limited by being represented by an attorney, since the Texas Code of Professional Conduct permits a defendant to have only 4 choices of input in his defense. 1, what plea to enter. 2, whether to testify. 3, whether to appeal. And 4, whether to opt for a jury trial, best said a trial by jury. Thank you for joining me. I hope you enjoyed that. I didn't read all the case cites because when I went through it before, it just sounded so much better without all those case cites. So I hope this helps you guys out. No, there's no image. No, the camera's not broken. It's just the screen's black. I do my best work in the dark. So I love you guys. Thanks for all your support. Share this with your friends and your family. Remember, freedom isn't free, and it's time to stand the fuck up and tell them all to fuck off.